There was a direction by the Honorable 10th of April to procure the certified copy of title the house. It was applied for, unfortunately, the certified copy procured and I've been just told that they will holiday. Tomorrow it will be procured. Thereafter it will be sent in connection with title. If minor, there is a direction of the Honorable producer.
Did I die?
Otherwise, once it takes it up, I have got it. Yes, something like that. Order another 10 minutes, I have to present 11. You're confused.
Oh, you forgotten that I don't remember. That could be there. No, I don't continue something. Like you do it by yourself and help you.
Worship item 29 and 30 with connected matters here. Worship the cases have arisen out of title suit number 321 in civil judge senior division Golaghat and the case has been amicably settled. The board to itself may be allowed to withdraw this case. Put the
The name,
speak of it.
the name is not there.
Hearing for hours.
Ask anybody in the matter.
Public. Attack for this thing in ISC for orders.
On?
For orders, ISC.
Hold on.
It is a combination of debate for preferring a CRP.
Take 26 of April.
Technical question, they will be
14th of May. 18th May.
Thôi một trường này thêm one. Thêm one.
is by the signed by the aspect of date of one. Subsequently, my lord, payment of my lord, I informed the honorable tribunal, but time granted for some. And my lord, due to my lord, COVID contamination, I did not obtain my lord, its certificate as well as my lord, health inside. On the ground of confirmation of my subsequent petition, my lord, is checked. The claimant. And my lord, next thing certificate, my lord, page 26, my lord. My lord, death certificate as well as my lord, extreme certificate. I filed my lord, application. But on filling down my lord,
If someone tell me whether this person concerned was in any manner you guys for whose claim you have filed circuit,
my lord,
circularly. Circularly. Circularly died in the accident.
my lord, yes, died in the
So under such circumstances, whether you had anything where you running, where you staying with him or you were any manner you had, how can you be a claimant?
my lord, initially wife filed that claim.
I mean, wife is okay. Wife was a dependent.
Yes.
Where you are dependent.
My lord, now my lord, it's process kindly people phase 26 months. Phase 26
That
is
is okay. But where you are dependent, if you are not a dependent, then under what circumstances you can be a claimant?
my lord, right, my lord, as per my instruction, my lord, I am the
How? How were you a dependent? Why didn't you become a claimant at that point of time initially?
person.
Why? You were therefore never a dependent.
My lord, wife and accident victim, or writing my lord,
In your house. So how does it become that you are a dependent of the deceased?
my lord, my submission, my lord,
You have to show somewhere that you are a dependent. Forget about the other delay and all. We take care of it. But whether you are dependent, if you were not a dependent, then why were you not a claimant initially?
my submission,
Your right is because you are the cousin brother of whom?
can be.
Then
But this part, my lord, we person kindly consider, this part, my lord, yeah.
Huh?
At this stage, my lord,
at this stage the case is for dismissal.
my lord,
Unless you show that you were a dependent, because of that you are to suffer. How do you show? You don't become a legal representative out there. You have a right.
my lord, my lord, I am dependent on what I will.
Where have you mentioned that you were a dependent in your petition? Let us see.
My lord, failure certificate, my lord,
Legal air certificate is different. Legal air certificate we have only obtained it on 6/4/2023.
my lord.
Did you have a legal air certificate at that point of time when the victim had expired then?
Now, my lord, I have my lord, on the ground, my lord.
Not on the question of condonation that you are nobody. Finally see the order. The order is says categorically. Kindly come to page 35 now. Consumer Begum being her brother. Thus the Saifuddin Ahmed claims that he is the sole legal heir of the deceased. Thus Consumer being her brother. Consumer is your brother.
That's nothing, bro.
Okay?
Otherwise, my lord, otherwise, except this petitioner, my lord, who one is the dependent.
So what? So you don't have a right.
My lord, I admitted it. My lord,
Huh?
the insurance company come, my lord.
Not necessary. Unnecessary type petition should not be allowed.
Otherwise, my lord, the entire my MSC case, my lord, will be in fact lost.
So what? You don't have a right.
Amen died during the my lord, I could not obtain the certificate. That's why I could not.
Legally as certificate.
Failure that is the death certificate, as well as death certificate of the payment. By claimant. my lord, a long process to obtain my lord certificate as well as a certificate. That's why my lord, immediately after obtaining two certificates, I filed the. But
You obtained it on 6/4/2023.
my lord, I obtained my lord,
On 6/4/2023.
my lord,
Come to page 26. It is dated 6/4/2023.
13/4/2000.
Why were you not a legal aid earlier?
A certificate obtained by on 13/4/2023 and the next is certificate on 2/5/2023. And immediately after obtaining certificate, I filed the matter. And in the meantime, my lord, tribunal also.
Forget about the delay. I'm saying, I'm not concerned with the delay, but show me how you were dependent.
Otherwise, my lord, yes, we do.
So what?
My lord, we also can you consider a next in certificate?
Experience certificate I've been.
And I examine my lord. Sir,
How does it matter? Experience certificate. Experience certificate, why you were not initially attaining? Why? Why? And your experience certificate should be from whom? On Zuma. Why have you got it from Saipur?
certificate,
Page 26.
big man.
Why have you got it from Saipur?
I think my lord, because the my lord,
Then why didn't you become a claimant then? Then? Okay. Mr. Huh? No consideration. You should have got this matter listed earlier before not to become.
I will examine my lord.
You will examine why the question of you being a claimant.
That's fine. Sir, I am in now. I will examine for tribunal, my lord, satisfied my lord, on being furnished my lord, evidence, my lord. You will be- And otherwise, my lord,
Look, first of all, you have to satisfy me because that is one of the grounds. I'll have it on Wednesday. There's one judgment of a recent Supreme Court judgment. Have a look at it. And then come back. Okay? Be okay. Otherwise, I'm not allowed. You can ask- If there is a judgment to the Supreme. Otherwise, you go to. Yes, Mr. Das, what you are saying also.
sir, my lord, some of the petitioner was the pending. And my lord, while the it was in the stage of my lord, proceeding of the witnesses case, my lord, then from the evidence, my lord, of Ratman always from the petitioner can to know about the exact, my lord, tag number of his land, my lord. That was identified by the Kundal. It was on 25th of April 2024. Accordingly, he filed an application and under order 17 for amendment of my lord, the tag number. That application, my lord, the application. Page 51. And page 51, this is the application he filed under, he filed under order 17. My lord, the annual patta number was wrongly written as 16, which should be 63. And in the my lord, boundary, that the north side should be Gobar. These two amendments. After identification of land by the evidence of my lord, the lot mantra. However, my lord, landed court below by order dated, my lord, 12/3/2025. My lord say that was has to be filed at the before trial. And since it is filed after commencement of the trial, this application was rejected to be cost of rupees 2,000. So we are challenging that. Humble submission, my lord, for proper administration of contribution between the parties, amendment may be allowed, my lord. And my lord, perhaps there is no absolute rule not to allow amendment. Although this is discretion of the court, my lord, and discretion should be justified. There is no basis on our part. By the evidence of my lord, government of the land has been identified. So therefore, we find the amendment. And my lord, suit is at the next date of 15/5. 15/5 suit is speak.
Why did you file it on 8/11? Lakmandar's evidence was on 25. Why?
That,
Your petition only contains 2 paragraphs.
my lord, I am also worried about that kind of petition. However, my lord, that contains what required in the amendment. In my humble servant, that is there.
What is
So, my lord, the amendment is for my lord.
what I will say?
In the prayer, my lord.
What does it say?
Under the opposite rights and circumstances and for proper execution of the suit, state that your owner may be specifically pleased to allow that prayer. Yes.
Then,
Well, also for the amendment, is passed on. We have written it as 16, my lord, annual pata number, that should be 63, and the northern boundary should be Gopal.
number 63. And where have you mentioned what is the required amendment?
My lord,
I will see page 51.
Yes.
What amendment you are asking for?
there are one, my lord.
What do you say?
In the schedule of the plan, the annual pata number of the Sultan was only written as 16. Which should be 63, which comes to the knowledge of the plaintiff very late. And it is not a Gobat is coming. It's the written with wrong assumption that the land of Nikhil Borali, whose land is at least
So what is your suggested amendment?
of my lord, annual pata.
Understood. Where is your suggested amendment? Where do you want the amendment to please? Where?
No, it cannot, my lord, develop this now, my lord, because this is the, my lord, on
You
the
can
court.
develop by paying a cost of 1 lakh. You can develop.
My lord, the council there is the Dhamadi.
Somebody or wherever it is. Execution for the problem by way of registered as well as details during the course of the day. Who are the performers? Are they performer? All are independent. Independent, yes. In addition to that, the petitioner is further directed to take steps by way of rescue, report to the registry of this court and file an affidavit of service on or before the next day. The case of the petitioner hearing is that the petitioner had filed the suit before the court of the Munship number 1, Yamagi, was registered and numbered as title sheet number 2/2018. Taking declaration. Taking
Case 19, my lord, for the recovery of the
for recovery of possession as well as for permanent injunction. So in the state suit, the description of the land was wrongly mentioned as Emil Patta number 16, which ought to have been Emil Patta number 63, and the northern boundary to have been Bhubat, but it was mentioned as land of Nathan Bharan. In the case of the petitioner, that when the Lakmandal was examined on 25/4/2024, the petitioner could come to learn that the land has been wrongly described in the claim, and under such circumstances, an application was filed for amendment of the claim, which was rejected. Mr. P.K. Das, the learned counsel appearing on behalf of the petitioner, submitted that as per the provisions of Order 7 Rule 3, read with Order 20 Rule 6 or Rule 7 of the court, it is also an incumbent duty of the learned trial court to see to it that the land has been properly described. We therefore submitted that the plaintiff, the amendment which have been sought for by the plaintiff ought to have been allowed. Taking into account above, this court is of the opinion that the petitioner has been able to make out the prima facie case for grant of a stay of the attitude number 12 till the next day. In that view of the matter, the further proceedings of attitude number 2/2018 pending before the court of the Civil Judge Junior Division number 1, its state to the next day.
Affirmative item 48.
1 lakh. 1 lakh. Because I'm having it on 9. Get ready. This is only a time being granted to you to get a lakh quickly. Yes, Sir Roy Chaudhary, what are you saying?
I application for order to order 23 rule 1(3), and also withdrawal with the liberty to file. Rejected on the ground that, my lord, I could have filed an amendment application there, and my lord, because at page, the finding is at, my lord, page 68, there are 14 and 15. Some the finding is.
What is the ground on which you are applying
My
for
lord, my
liberty?
vote was of the Patwara case I filed. The parents of the defendant and the parents of the plaintiff were brothers. So they are having a joint property. Then, my lord, I filed a Patwara case on the basis of which I got a position, partition of my part. Then, my lord, on which they were in position. So I sought for right title interest and asked for it. My lord, they filed an written statement and stated that my parents had sold an unregistered sale for ₹95 by portion to somebody else. So I want to bring it to the court because that source of my title was that document of my parents was not there in my place. So I want to withdraw by the bridge with that source of title. That but the trial court held that different source of title maybe for an amendment application, and putting a different source will not constitute a formal defect. Will not constitute a formal defect, and my lord could have filed an amendment application. That is at page 68, para 14 and 15. The findings given by the trial. Here, it was allowed, but it was ex parte, so the other side approached this court, and the court set aside and remanded back for finding a written objection. The written objection, they stated that this document never existed. But we know that nothing has, no right has been heard to break this down.
So what is your source of title now?
My source of title is by the father and my parents. The title is the land documents which are in my name of my parents. Those is my source of title. I have to think. That is in my application of for withdrawal is at page, my lord, 45. It starts at page 45.
Why don't you include the document?
My lord, I have included those documents. They are in, my lord, page 32 onwards. And page 38, your lordship will find. That's page 34 is also there. They are also survey. My father's name is Shyam Charan. My application for withdrawal is at page 45. I have sitting in para 6 and para 7.
So is it the same contract?
But my whole suit was on the basis of the Patwara.
But is it done on the same course of action?
Things I don't mention. I can also say, because if that idea is true, now when they have filed a written section saying that my father, who said I'm for 95 rupees, has sold that plot of land to them. That is why my lord, I would want to have. Those who took them find out case.
Right.
Because my lord, at all, my lord, those of title, telling, there is my change, my lord.
Why you are not challenging?
Plus, my lord, I have this fact. They have filed for it. But never mentioned.
So why you are not asking for an amendment?
People of that I find they consider my case that
Both have observed it. Why
well,
should I?
who has only said to them, but yeah, my only case is that was my grade was also not you're not looking for my grade. And not somebody drafted not that specifically drafted the 2-page grade. You'll have to find the page at page 15. My whole case was on the basis of a Batwara, para 3, page 16.
What is going to happen when you file again another suit after 2017, another 8 years down the line?
Because Bharat, at all,
Only if they file the written statement? When did you file the written statement? Then what were you doing? Sleeping?
Bharat,
Sleeping?
at this moment, because nothing has developed to
In a case for dismissal, right? Okay.
only thing Bharat will also that at all requirement is find an adequate application. And Bharat,
Where is it the court has observed that you could find a challenge it?
Bharat, there are 14 and 15 of the judgment, 6 page 68.
You can find an amendment. You explain why do you need to protect? Otherwise, you are subverting the six.
I do also claim by amendment, then Bharat again, amendment claim, with that they will be given the opportunity of filing it. Because that will delay the, that will definitely, but if it is withdrawn, nothing like as a whole to them, because it is cross Bharat. So they came to them, cross Bharat. That will progress very fast, otherwise, another 15 years will go to this way. So we know that that will help them. Total consumption, the cost being for them.
One lakh.
1 lakh will be too much. At least, well, you're lucky to give it 25,000. You're lucky allows me,
2017,
well, because now,
2018, they filed. How? What are you going to take about his litigation expenses?
this is.
No. Mr. Eldas is an expensive counsel. You have to engage him also.
God, I will need to pay 25,000.
Huh?
I will pay 25,000.
No, no. 25,000 is too much.
But you're lucky to think because.
How much?
What's it?
Let them go ahead. Nothing, no right here, but I think the point is, once to withdraw with the liberty, then pay the cost of around 1 lakh. That is the only, no, because 2017 onwards, 8 years down the line, one has to be reasonable.
Well, taking into view because this both our parental property and now they are saying.
Who was parental property? What do you mean? Why didn't you wake up in 2018?
Well, two cut 9 lectures. Only two cut 9 lectures in Borpeta. In a remote village. Two cut 9 lectures.
Really?
Yes. Yes. Outside. Two cut 9. They are Borpeta. Well, two cut 9 lectures. My shape. That much is not the cost of my land also.
Yes, Motuapuchi town of Borbeta.
Yeah, but it was not.
Okay, then we invoke that you purchase, give him 1 lakh. You give up your right.
Well,
You say, give him 1 lakh. Give him 1 lakh. You take it. You say that it would not be the value of rupees 1 lakh. So give him 1 lakh. You give up. Okay, we have it on Wednesday. We have it on Wednesday. Get that instruction. He will pay you 1 lakh. You give it. You give up all your rights.
I think Malad going by down, it down.
No, no,
Malad,
nothing.
only thing, a reasonable price may be quoted, Malad. Malad, I will pay that.
No reasonable price. This is 1 lakh.
Cost.
You say that even it will
Price
not be
cost.
a price of 1 lakh.
Malad, cost. Malad, what I am doing, the word is wrong, Malad. The cost. Reasonable cost may be good, Malad, I will pay that cost. Malad, and means what will be fine, that will be an huge expense. Again, finding a school will be an expense. Again, Malad, because amendment, if I file, Malad, they will file an order. Again, Malad, the amendment claim, everything that will take a time. Otherwise, the school, because they are in position, I am not in position. I'm asking a first position. They are in, my share is also for first position. They are enjoying the property. My parental property.
No, not interfering. Go there, file an order 627.
Then you have to observe the final application and the proof is that's what I not.
Why should I say that? The court already says.
But court says that and you explain everything, Malad.
Yes, obviously you will have to explain.
I
You will have to explain why on earth from 2018 you were sleeping. You have to explain.
that definitely will do, Malad. Only thing.
1 lakh is too less. 1 lakh is too less.
Not 1 lakh is not possible for.
2 lakh. 1 lakh is too less. Even 1 lakh would not be, cannot recommend the lawyer's expenses, filing of a written statement, going to the stage of evidence for 8 years. If you take per day appearance and trial courts per day appearance goes. So 1 lakh is too less. Maybe there are 2 lakhs.
All of that is definitely not possible for us.
Heard Mr. P.K. Vachodhary, the learned counsel appearing on behalf of the forensic accused on behalf of the respondent. The petitioner has invoked the extraordinary jurisdiction of this court, supervisory jurisdiction of this court, challenging the order dated 4/2/2025, whereby the application and the order in 23 Rule 13 of the Code of Civil Procedure 1908 was rejected, thereby observing that there was no formal defect or any other good grounds for which liberty may be granted for filing a fresh suit. Full. This court had duly perused the order dated 4/2/2025. This court had duly perused the claim as well as also the written statement so far. It is relevant to take note of that in the year, the suit was filed in the year 2017 and the written statement was filed in the year 2018, wherein the defendants have brought on record their source of title. So, taking into account the above, this court does not find this the jurisdiction so exercised by the learned trial court to be an error for exercising the supervisory jurisdiction of this court. It is, however, relevant to observe that at paragraph number 14, the learned trial court had duly observed that if the petitioner who is the plaintiff in the suit wishes to file an application for amendment, the same application would be duly considered. Taking into account the above, this court, while not interfering with the impugned order, grants the liberty to the petitioner to file an appropriate application seeking amendment of the claim. And it is further observed that if such application is filed, the preliminary trial court shall will consider the same in accordance with the above the usual petitions discussed.
Okay, I know.
All right, based on item 3,
Yes, what has happened?
Page number 157.
Page number
157.
they will challenge. Again, same. So, why should we interfere?
Actually, what happened in this case? My grandfather had persisted lot of land because he got a personal son. I have the dead pussy. You know, what happened in this case? Accordingly, being a legal, I had it our name in the year 2017, Lordship. What happened in this case?
For whom are you appearing? You are a petitioner in person.
Yes, Lordship.
So you are appearing for number 5.
Yes, Lordship.
Who appears for number 1, 2, and 3?
They are authorized me to represent.
Can they? Can they? Can they authorize you to represent? You can only represent as a lawyer. In the court, either the person has to appear or through the lawyer. You are number 5. Understood. But what about 1, 2, and 3? How are they appearing?
Right. For my
4 is okay. What is 1, 2, and 3? How is 1, 2, and 3 represented? Somebody has to represent. You cannot. If you are the petitioner in person, can you? You can appear only for yourself. Can you appear for somebody else? Being a petitioner in person. What to do? Then tell me.
what happened in this case? When I
What happened is different. What about 1, 2, and 3? Will not represent. Okay, now come to a point. Because tomorrow I dismiss your petition. Then 1, 2, and 3 will go unrepresented. Because you can't represent 1, 2, and 3. Anyway. It is possible. No. You can represent 1, 2, and 3 without the gown. You can appear for 4 very well. But what about 1, 2, and 3? Still, give me a good one.
Try this inform them to appointed leader.
Yes. You get somebody, get their vocal number signed, then I'll give you. Okay. When do you want it?
That's what convenient.
I'm not the. Every day, I'm here to sit out. If you're convenient, you have to get hold of somebody.
After tomorrow also.
Fine?
Oh,
Yes, what do you need?
Person I know.
Hmm?
2018, why the reason within agreement
What are you challenging, madam?
does that
Which order are you challenging?
was allowed you. Within then find it. The written statement that of defense is not the same thing. The only ground was that he had gone to the OPD, medical ground, not a grade. And the matter proceeded expert. And then evidence was also filed. Thereafter, written statement, cross-examination, the summary procedure, all of whereas, I mean, it's kind of simple that we have a ground enough for the because we didn't, it was not efficient form. I think the attack was a simple document of the bill. That was not pertaining to the property. So that is all we wanted. We didn't want the matter to proceed expired.
So you are challenging which order?
They did, four orders have proceeded against us, but they did 411 here.
Or
That's number 7, Annexa 7. Annexa 7.
Extra 7, we don't have an extra 7. Extra 7 is the review order.
The review
Yes. You are challenging the review order.
order and this one, 4/1/2024 and 6/3.
No, this is an order checking review. Which order are you challenging?
Both of these orders.
No, this order.
Because the procedure is, procedure as a process of summary procedure was
You are challenging 3011.
3011.
Wait on. You have put up review of the order asking share to the party order asking. Where is that mistake case order?
The mistake case order is, the 3011 order is Annexa
That order is not here.
4. Annexa 5.
Huh? There's the order, 3011.
Fine.
Huh?
The remaining portion is in the file.
Madam, without challenging the 30/11/2023 order, where is that order?
Yes, not there, my lord. The copy of the order should be Annex 5. But-
Annexure 5 is different. Annexure 5 is the consequential order.
Order
Where is the main order?
is six, what is it?
Answers for the commission of 6 for 4 weeks time. To bring on record the order dated 30/11/2023, fasting will say case number 490. In Annexure 5 is 37. It's 37, it is mentioned. It takes such a long time to get page
Yeah,
96/2000.
26.
I say order be brought in record and final minutes. Is the matter. You bring your written statement on. I. Yes. You have improved. Yes, what are you telling me?
The present, is that judgment ordered in the high judgment order or by the land just allowing the sure allowing the resolution for one allowing them forbid develop the drug
Yes, what are you challenging?
the drug. If it's big fact,
You are appearing for the respondent?
sir,
Respondent number 1 and 2? Huh? Is the husband?
yes,
Why you don't know? Are they not in talking terms? Husband and wife?
they are living together.
Then, here for both. Here we have to raise 1 and 2. Which- because it's- Oh, no, no, no. The defend number 2 is separately. Yes. Here for the half of this. Which- and then- of the um, two still make it. Thinking that the line of the Indian subsection of it, challenging the judgment of the dated 2/5/2022 past I think so on the floor would be something which they deal with it or which the station is the matter. We get the action of service. But if you an application for stay. Depend. Parents of the parents of service upon the responsibility dispense. respond with an application file. Eight state by to have speak lunch number two, commitment number three, debate direction number four, to be one, which is taking into account by the score table to begin that an end and improved judgment and order. And by the improved judgment, the debate has already been debate have been drafted in favor of number one. Meaning that in order to safeguard the interest of parties, impugn judgment and like full parts in council is required to the state and the disposal of the accordingly impugn judgment and judge the state with disposal of the liberty to the parties to file a petition when we hearing of the
Six.
substantial question of law. Means it under the Employees Compensation Act. Means it required to be on a substantial question of law. But not. Isn't it? Well, this can be an appeal like this. Oh, employees compensation. You have it? Employees Compensation Act. Appeal lies only on the substantial question of law.
Appeals, appeals lie to the High Court on following orders. Concern namely, and the judge, there's somewhere in my 38.
He provided no appeal shall lie against any order unless a substance is involved in the appeal. And in case of an order other than an order referred to, unless the amount is disputed in less than 10,000. So. Estimated and council hearing. That you file separately within 7 days. Substantial question of proposed substantial question of law which are involved in the instance. Is the matter. Two.
Seven.
Yes, what is this?
The detailed statement was expected because 90 days expired. If 19 connected to the order.
By the other side.
Each of these group members will be taken step by step. And doctoring law, who can respond and has accepted it was is by nature.
Why was it you because?
Because this elected 19 minor. Sorry, elected 4 base 19. And elected 4 base 19. So,
Page 19. The final picture page for another day. Detail of the case which was revealed separately. example, it feels as a limitation of activity will be expired. Then,
If 17 is the petition with fine. Nothing.
then,
That number one, 4 1 minus we have submitted of
for one, bring that on the
in addition, if it is you want to correct it, I just definitely the order 4/1/2025, we have 5 pages.
you find the 151. Where do you find the repeal statement?
And of that, the order reflects.
Huh?
Page 23, NHF 5. Side copy.
You have filed a counterclaim also. $25,000.
Technically, it was 10,000.
No. 25,000, you take it as a. Because you see, if I allow you these type of things, then things will go everywhere. Order 821 becomes standard. And recently, the Supreme Court has also come up with all those things. You are getting a double benefit at page at 25,000 first filing of the written statement and the second the counterclaim of. So you are having an additional benefit. No, okay. Because of you, I'm making it only for people. Otherwise, you must have heard it in the morning. I was starting at 1 lakh. I must say, and hope the legal counsel is getting up. In fact, when I moved past that order, I told you 30,000. I remember.
Yes, last operator, my question.
I told you 30. Now I'm making it 5,000. But the other side, I was the legal counsel appearing on behalf of the petitioner. Was petitioner, huh? Half of the petitioner. One appears to be part of the responsible in spite of due service being effective. That is an application to by invoking the supervisory jurisdiction of the school under Article 7 of the Constitution, challenging the order dated. Five 10/2024. Millions. The subsequent order dated 2/1/2025, whereby the petitioners have been debarred from filing the written statement on the ground that 90 days have elapsed from the date of service of summons. It also related to take note of that the petitioners had quickly filed a written statement come counterclaim to 2/1/2025, which was also rejected by the learned platform. So have really finished the application to file before the court as well as the additional affidavit. The end of the by the submitted, the legal file could not be need to take note of the provision of what was of the code of civil procedure 1988. Also, the fact that in the issues are not framed, the question plaintiff, the defendant, usually has the right to file a claim. This would have also examined the grounds on which that time was sought. And in the opinion of the court, the limit right to have accepted the written statement or to have granted a further chance to the defendant to the petition to file the written statement. This could have also taken note of that fact. The written statement that the claim had already been filed. However, the learned trial court has rejected the same by the order dated 4/1/2025. So taking into account that the procedural laws are always subservient to the interest of justice and the petitioner could suffer irreparable if the written statement is not allowed to be, if the statement is not allowed to be taken to the court. This was interfered with the order dated 5/10/2024 as well 5/10/2024 by which the petitioners were debarred from filing the written statement as well as both of the order dated 4/1/2025 whereby the written statement come counterclaim filed by the petitioners were rejected. Accordingly, this court directs. This court, however, cannot be unmindful of the fact that there has been certain latches on the part of the petitioner in not filing the written statement as well as the counterclaim within the period stipulated. And which under such circumstances, it be restored for the interest of justice to include the cost of is 25,000 upon petitioners, which shall have to be deposited before the learned trial court or before on the next date, so fixed here in the under. With the above observations, therefore, the instant petition stands disposed of. Disposed of. One, the order dated 4/5/10/2024, whereby the petitioners were debarred from filing the written statement is interfered with. Number two, the order dated 4/1/2025 by which the petitioners written statement on the claim were rejected is interfered with. Three, the petitioners are directed to deposit the cost of rupees 25,000 before the learned trial on the next stage. Upon next proceeding, this is seen from the reports that the further proceedings of privacy in stay, they will stay, no?
But next date is 11/6/25 for ceremony.
There is no stay. This court has been brought to the attention of this court that the trial court that the next date before the trial court is on 11/6/2025. On the same date, petitioners are directed to deposit cost of rupees 25,000 before the learned trial court. In such deposit, that written statement come on the claim so filed by the petitioners and to be taken in report by the learned trial court. First, this court number 4 this court further grants the liberty to the plaintiff to file an application before the learned trial court for release of the said amount. And such application is filed, amount of which 25,000, and on such application we file, the learned trial court shall pass it to.
Eight.
Yes, what is this? Oh, recently the Supreme Court has also come up with that judgment, na? Is the judgment? It's a very recent judgment. I think 4 5 days back. You have not? Here. Okay. Exactly on this point. Yes. Yesterday was not helping. fact, the judgment which I passed on 2023 4 SCC seems to be the same proposition held by that I have asked my fellow. I have passed some order whereby they will be getting, I will be staying the entire month except expenses during treatment. Expenses, and all these, when you come to page, calculated, then that. So these you deposit, no? Therefore, this page 32. Well, expenses due to friends, also influence of funeral and yeah. How do you come to 10 lakhs? Sorry, madam. Try to set up. No. You don't deposit this dependency, nothing. But you deposit this in time. That's what I. From 2 to 5, 2 to 6. You deposit, they will take over this. Only this amount. What is the total? Yes, you have not calculated. There's one judgment has come, Madras High Court, 149 crore. We seen it. Yeah? Really explains how it is not there. It goes against you. The present appeal is that is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment in more dated 2025, passed by the learned member MACT Borigaon in MAC case number 32 of the 2019, awarding an amount of which 40 lakhs 04,464, along with interest at the rate of 6% from the date of filing of the claim petition till realization. Mr. R.K. Bhatta, the lower counsel appearing on behalf of the appellant submits that taking into account that the claimants are getting the benefit in terms with the notification dated 14/9/2017. Insofar in as much as they are being paid the last drawn wages, last drawn salary of the deceased, the amount so awarded as per the dependency on account of the head of dependency of rupees 33,74,748 by the learned tribunal was not in accordance with law. Taking into account the said ground of objection taken in the instant appeal, the instant appeal is admitted to on to the reports. The petitioner, the appellant is directed to take steps of 2, 3, 4. Why 5? 5 you are representing. But you need 5. You are not challenging on those. 5 and 6 not necessary. Your only ground is there. 5 and 6. The second respondent of 2, 3, and 4 who are the claimants by way of registered as well as usual. Taking into account the round of objections so taken, the names of the respondent number 5 and 6 are struck off. Counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court. and the registry shall, on the basis of the said memo of parties along with the instant order, update the same, make necessary changes in the cost title and update the same in the CIS. List the matter immediately upon completion of service upon the respondent. Is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908 for stay of the judgment and award dated 21/2025, passed by the learned member MACT Morigaon in MAC case number 34 of the 2019. First of taking into account the ground of objection on which the appeal has been admitted, comma, this court stays the impugned judgment and award till the disposal of the instant appeal, subject to deposit of an amount of rupees. What is the amount? Huh? What is the amount?
What I say?
226. How much? Don't suggest anything. What is 226?
The amount will also accrue to interest on 6%. I have calculated the amount. Comes to 8,26,000.
No, no, you see, you calculate this, 4 lakhs to 10,000, how much it is?
Color it comes to 6,29,000.
Deposit the amount of rupees 6,29,000, 716, along with 6% interest with effect from 25/4/2019, within 6 weeks from the date of the instant order. Full stop. We have further observed and directed that the claimant shall be at liberty to file an application before the registry of this court, and the registry shall, on such application being filed, release the said amount, subject to verification and legal land for science.
Right.
Please, Biani, get hold of that judgment, recent judgment, and give it to him.
Look, I am telling same ground.
Same ground.
Yes.
future prospects being put so much? Can you come to page 18? Paragraph 21. Future prospect, 15% of rupees so and so is equals to 56,000. Then what is this 5 lakh 4,000? Where do we get it from?
5,04,272.
Where does he get this amount? We should have added with this. We should have added with 3,78,000, I think. So this one. Loss of dependency. There's something wrong, na?
It was drafted by my colleague, but he's the draft. Like,
No. The drafting, I think, obviously was not done by you. It was done by the court.
something is wrong.
Okay, same order did you go? Ali, equal subject to state payment of is 44,000 has now become 48,000. Yes, 44,000 has become 8,000. 20% increase in the 48,000 plus 16,500, 15,000. It is to go high. Along with interest at the rate of 10%. When did he die? 2024.
Yes.
And when was the date of filing of the application?
It's
Application filed when? These people, they don't put the date from date of filing. Yeah, about order to Muslim. Huh? Take to stay of this. Huh? Take it in. Total amount is 44 plus 53. 77,000. Huh? Along with interest at the rate of 6%. The date of filing of the application. Date of the filing of the application was
file.
Huh?
Yeah, I will not
give it to them.
file.
When did they file? The date of the filing of the application before the learned tribunal. I Yes, very good.
But, file a suit and an injunction petition. Now, the injunction petition also had a prayer for identifying injunction protection. Now, page 139, you will see the order where just notice has been issued, by holding that it is property. Here's the order. Now, the case that I may not have pleaded in my
What happened on 11/4?
2910.
What happened on 11/4?
11 for when the matter was wait wait for some time on 23rd for the case. Yeah. And vacation mallet was also there, so 10th order
What
passed.
is your injunction you are asking for?
Well, injunction to the extent mallet of restraining the opposite parties from their management from in any way changing nature and feature and character of the suitland, and also restraining them from alienating the suitland in the
So what was your urgency?
well, urgency, your lordship will kindly see page 132, paragraph 9. Well, on 29/10/2024, by application of force, we have been disposed from the suitland. Thereafter, we lodged complaint before the police. I have even enclosed one of the complaints that I had lodged before the last order of this honorable court was also to the extent of asking me to take instruction regarding the fate of the police case. I have taken instruction. The police case has not been registered as yet. Your lordship will kindly see my complaint is also there before the police at page 97 that I have annexed.
What right you have over the land?
Well, this land was handed over in possession to my predecessor way back in 1971 by the original owners. Now, these owners are not residents of India. They actually are the residents of Bangladesh who occasionally came to India. One of the brothers who resided in India sold his share of the land and exhausted his share, even more than his share. Now, we, through our predecessors, have been in
So
possession.
you don't have title.
Title. No, mobile. We are looking after the food land by going crops, which we have been allowed by the original owners. Now, out of those owners, those who were the pattas, they had relinquished their right title from the pattas by way of sale. Now, even
In whose
after,
favor? In whose favor?
in respect of purchasers who had purchased those land. Now, so far our land was concerned, that remained. Now, thereafter, the respondents herein, in some manner or the other, they have been filing one suit after the other with injunction petition on the ground that they have right title over the food land, food patta. And they have been seeking injunction by saying that they have been disposed from the land. As many as 4 suits were filed. In those suits, injunction prayer was made. All the prayers were rejected. Now, eventually, my lord, the last suit that they had filed, in that also they had a prayer for injunction. That prayer was rejected. We filed a petition under Order 7 saying that the plaintiff is barred by specific provision of law, have the issue having been decided on previous petition. Then, during the pendency of that suit, they
So
surreptitiously
did
filed.
you suit under section 6?
Yes, under 6 of the specific relief act by us. So, but that suit that was filed by them was concerned. During the pendency of that suit, they filed a petition for withdrawal of that suit, saying that the matter has been amicably settled between us, the parties. And the order that I have annexed, my lord, your lordship will kindly see, the order that has been annexed pursuant to their withdrawal petition is at page 101. Now, here, this order also, in my respectful submission, is a perverse order, because here it says both sides were represented, page 101. This is pursuant to their petition under order 23 rule 1 CPC. Now they say, and this is the date, my lord, on which we were rather taking up the issue with the police. At page 97, I have annexed that complaint before the superintendent of police.
So what you are asking is that from evicting cash possession in favor of the AR and perform dependent by evicting the principal dependents by a main enemy is exclusively by principal dependent leaving it to AR. And we are from changing the existing nature, feature and character of the suit.
Now, this was our prayer in the injunction petition. My lord. Now, only thing that, my lord, we are saying for hearing, at page 139, your lordship has seen the order. Here, my lord, we have been asked to take steps upon the other side. Our only apprehension is the moment they get to know about this, about the order, about the suit that we have filed, they will rampantly, my lord, resort to activities which will either be in the way of, in the nature of changing the nature, feature, and character of the student, or alienation of the student. And thus, my lord, we had prayed for an interim protection till the disposal of the injunction petition as well as the suit. Now, because of the fact that this, our prayer under Order 39 Group 3 has not been considered, that's why, my lord, we have.
But why do you take time on 11?
On 10 for this matter was discussed. For this one, so your lordship will see the order where we actually were direct. In fact, before that, we filed a revision. There's an order of this on the court where I have been given, I was given file. Thereafter, my lord, on 10/4, when this matter came up, this honorable court wanted to see the certified copy of the plaint. The reason being, my lord, there is some hand correction in the copy of the plaint as well as in the injunction petition of the suit, the present suit that is in question. We applied after being directed, we applied. However, the Raptor told me the copy will be procured tomorrow. Today, there being a holiday day. So on 11th, we had to, my lord, take an attempt because we had not taken steps upon the opposite parties as per the direction in the order which is in place. So we had to take time that date saying that
So what are they going to do?
well, our apprehension that now they have disposal skills and now they are in possession.
They have already disposed.
Yes, that
Then
is
what
the
is your
reason
intent?
why we are more apprehensive. The page 97 is the entire story, my lord. And that is what we have narrated in our injunction petition at page 132, paragraph 9. So, the urgency is because of this.
So that's supposed to be, we don't notice, do nothing. We will leave it people before the trial court on 23rd to reconsider on the existing facts as to whether there is a necessity for an indictment and let the court consider that. I'll be, if that is a better. But having two parallel procedures
Will not make, otherwise also it will.
and I've understood one, two defendants is okay, but a post of 25.
You know what is my suit, my lord, where I have been disposed of.
Well, under such circumstances, without interfering with this, I make an observation to the effect you file an application on 20 for the trial court. With urgent relief, good reasons, and the trial court shall duly consider the
I'll be taking you.
then again, the 25, whereby the level of trial court Court of the Civil Judge, Senior Division Number 2, Charles Richard, had notice without granting an ad interim ex parte injunction in favor of the appellant, who is the plaintiff in the suit. First, in the course of the hearing, the learned counsel appearing on behalf of the appellant submitted that the trial court ought to have considered that there was urgent necessity for an urgent relief, which ought to have been an urgent relief. There was an urgent necessity of waiving notice under Order 59(3) of the code and granting an ex parte injunction order, thereby protecting the interests of the plaintiff to the extent sought for by the injunction application. This court, during the course of hearing further, inquired with Mr. Chakraborty, the learned counsel, as to when is the next date fixed before the learned trial court in respect to the injunction proceedings. That the next date is fixed on 23/4/2025. So in the this court having taken note of that continuing of two parallel injunction proceedings would not be in the interest of justice, grants liberty to the petitioner, who is the appellant, not the appellant, who is the plaintiff, in title suit number 39 of 2025, to file an application on the next day before the learned trial court, that is on 23/4/2025, and in due reasons as to why there is an urgent necessity for an interim injunction. This court further observes and directs the learned trial court that, taking into consideration the said application, the trial court shall pass appropriate orders as the fit in accordance above the instant instance exposed. Liberty, however, is given to the petitioner.
Maybe 21st.
Get it? By evening?
Attempt 10.
Might happen.
No, I don't think that would. I don't. That's right. I don't think it is secretary order. An order of reversal. My lord, the respondent has plaintiff and filed a suit for recovery of a certain amount, along with ancillary relief. But the suit was dismissed. As such, the respondent filed the first appeal, whereby the appeal was allowed and the suit was dismissed.
Who are you?
I-
Who are you?
I am my lord, the defendant. But as the appeal was allowed, I am here before your lordship in the form of regular second appeal, my lord. My lord, your trial court judgment, my lord, recovery of possession, number 5, my lord, is very much important. This case, my lord. Page number 31 is the judgment of the trial court. It was the issue was whether the plaintiff has right title and interest over suit property. Page number 38, 31, my lord. Issue number 5 is at page 31, my lord. It starts at page 27.
October 15. Early. Which move early?
Pramod Bharli is the was the husband of the present appellant. He was major party in the suit, my lord, but I was not a major party.
You became a party when?
After the demise of my husband,
Yes, me.
in the appeal, in the first act,
The substituted.
yes, my lord. Subsequently, I came.
Kosi Burali, who is the appellant is your mother.
Urvashi, what?
Burali is the mother.
No problem. Urvashi is the mother. Urvashi is the
You are
daughter.
fighting amongst your mother and daughter.
Mother and daughter. And
So what right do you have?
the background facts of the case is that the plaintiff's case is that, madam, being the mother, she was the owner of two acres plot of land, which she had given to the daughter as permissive occupant. My lord, their stand is that, but our stand is that, my lord, by way of gratification, we have been put into possession in the property. And if the,
By.
by way of gratification,
What is this
That-
rectification business?
that's considered in the.
No, what is this rectification? Let us also understand. I've never heard of this type of.
Yes, my lord, the gratification, my lord, it can be it may be genus of gifts, my lord, but it is not covered by, I am not established, my lord, but it's not covered by any of the branches of the transfer of property. Then, as such, my lord, maybe need to peruse my WS property. Because in my WS, I have taken the standard, I have been possessing that as the owner. As the owner, I have been possessing that land
How?
by way of.
Adverse possession.
Not adverse.
Then-
Not claimed adverse.
Then what right do you have?
I have been put in the position by my mother only.
So you are a permissive occupier.
No, my lord, but this by way of gratification, my lord.
Gratification.
Yes.
What is this gratification business?
Gratification, my lord, as far as I can understand, that is like a form part of the community I have been transferred to them. That is the stand which will be taken of WS. I cannot tell,
Is this land in Assam?
it's in my lord,
Also within the, not the sixth schedule. So Transfer Property Act applies,
yes, my lord.
Registration Act applies. Then what right do you have?
My lord, but by dint of this written statement, my lord.
Written statement is not a document of title.
By dint of the written statement, my lord, a cloud has been created.
What?
Cloud of doubt, my lord. Upon
So
the
that is why, what is the plaintiff asking for?
simply for recovery of possession. So, and example.
Then
But my lord, my stand in the statement, it creates a considerable cloud of doubt upon the right interpretation.
Oh.
Because I am feeling my
the
lord,
moment he is asking for, the moment you are saying that you have title,
yes,
the court had duly considered in the issue number 5, whether the plaintiff has right title in interest of the suit land.
it has been, that issue has been decided against the plaintiff in the trial,
The first appellate court have decided in favor of it.
citing that for recovery of possession, right title is for recovery of possession, my lord, right title is not citing that the issue of number 5 is been overturned in against me. But my humble
Unless you show that you have a better title, where is it? So question of recovery rightly done. She has the title.
my lord, recovery of possession for recovery of possession, my lord, has to prove her title.
Why?
Or she has a better title.
You have a better title.
No, my lord,
She has, for the purpose of that, she has produced the two deeds.
yes, in this they gets produced, my lord, but there's a certain comment in the Javaban says that the seller of the two deeds ought not have sold those portions of them. In that finding being there.
Are you not claiming title on the basis of the gratification done by your mother-in-law, by your mother? Then how are you challenging that?
No, my lord, but the title is with the plaintiff to recover the possession.
Not necessary.
Because she has to prove a better title.
Not necessary.
By dint of the gratification, I am saying, my lord, but
But the issue is there, issue number 5 is there, and the court have duly held it.
My favor in the trial.
Whatever may be, the trial was the first appellate court held it. She has the document of title.
Has been my lord, but
Then-
that has not been proved.
Why? Two sales leads were not exhibited.
Only exhibited.
Then-
but not-
What, did you question that?
not-
Did you question, first of all, are you not claiming, are you not a permissive occupier? As per law. You're a permissive occupier, you have no title. Unless you are claiming adverse possession.
I'm not clear.
You are not. You are claiming title through them. To that lady. To your mother. Then what right do you have? Are you vacated or not? When are you vacating? So your mother is not a widow. Is your mother not a widow? Then
The right.
we have now to impose cost. You vacate and pay another cost of 2 lakhs to your mother. Huh? Legal aid, so what? Because of all these things, legal aid, nothing doing. You cannot take away like this from your mother. Yes, sorry, state of this. How many the appeal up to the, you filed on 3/9/2024. Has the decree been executed?
But then
Good.
it's on 29.
Yes, when you are vacating 29th of April, vacating. Bismillah. 6 months time,
10th of April.
then thereafter you cause another further problems. Vacate it, ask your mother, vacate it, and then ask your mother if they do it. It's not done. Yes, she. Your mother has how many daughters? Sons and daughters. You are the only one. No evidence also. Ratification.
But,
No
the
evidence.
husband of the appellant was made a part, was not made a part. Although they went,
Whatever may be.
the husband was not, the husband was not there.
Will defendant no evidence also for gratification. Let us dismiss it with cost of 2 lakhs.
What?
Cost of 2 lakhs upon you. 2 upon you. For filing these type of appeals. Mr. K. over the learned counsel, half of the appellant. balance. An appeal filed under section 100 of the Code of Civil Procedure 1908, for short the court, challenging the judgment in decree dated 14/7/2022, passed by the learned civil judge, Senior Division, Golaghat, Assam, entitled Appeal Number 2/2019, whereby the judgment and decree dated 6/6/2019, passed by the learned civil judge, Junior Division Number 1, Golaghat, passed in title suit number 4 of the 2015, was set aside. System. The instant appeal is being taken up at the stage of Order 41, Rule 11 of the Code of Civil of the Code, where certain as to whether any substantial question of law can be formulated in terms with section 100 bracket 4 of the code. For the purpose of ascertaining as to whether any substantial question of law can be formulated, this court finds it relevant to take note of the facts leading to the filing of the instant appeal. For the sake of convenience, the parties are herein after referred to in the same status as they stood before the learned trial court. The respondent herein as plaintiff has filed the suit before the court of the Munsif number 1 at Golaghat, hereinafter referred to as the learned trial court, against the predecessor in interest of the appellant herein. The said suit was registered and numbered as title suit number 4/2015. A perusal of the claim of title of the said suit reveals that the plaintiff, who was a retired teacher, had acquired purchased 2 plots of land, 2 plots of conjoining lands by deed of sale, by 2 separate deeds of sale bearing deed number 484/399 dated 17/2/1988 of 1 Katha 5 lecture and the dark number 6229 pertaining to periodic patta number 250, and another deed of sale bearing deed number 1273/1041 dated 14/5/1991 of 1 Katha 10 lecture of the same dark and patta numbers. The plaintiff, after purchasing this 2 Katha 15 lectures of land, constructed kacha houses initially, and thereupon also constructed pakka house in the said plot of land. The defendant was married to the daughter of the plaintiff. Being in good relation, the plaintiff permitted the defendant, along with his daughter, to reside in the kacha house reside on the in the Pakka structured house. Listen, the defendant thereupon, the plaintiff thereupon asks the defendant to leave the house and vacate delivery and hand over vacant possession, which the defendant failed to do. And under such circumstances, a notice was issued on a legal notice was issued. In spite of the legal notice being issued, the defendant did not vacate the premises, and it is under such circumstances the suit was filed seeking declaration that the defendant, along with his family members, were permissive occupiers of the plaintiff's property, which is the subject matter of the suit, and for semicolon for decree for recovery of past possession, semicolon for a decree for mean profit, MENSC, as well as for decree for permanent injunction. The defendant, the defendant participated in the suit proceedings and filed a written statement wherein it was specifically mentioned that a daughter of the plaintiff, namely Sri Moti Urbosi Kotoki, had actually constructed the Kacha house as well as the Pakka house after taking delivery of the land from the plaintiff in the year 2002 as gratification. It was also mentioned that the wife of the defendant had started construction of the Pakka Assam type house building in the month of February 2005 and completed the construction work in the month of June 2007 with full acquisitions of the plaintiff, her mother. On the basis of the said written statement, on the basis of the pleadings, the learned trial court framed as many as 8 issues, which, for the sake of convenience, are reproduced herein under 1 to 8, page 31. It is seen from the reports that on behalf of the plaintiff, 7 witnesses were used. 7 witnesses were examined and 20 documents were exhibited. On behalf of the defendant, there was neither any witness nor any documents exhibited. The learned trial court, by its impute, by the judgment and decree dated 6/6/2019, dismiss the suit of the plaintiff. On the ground that the plaintiff has not proved a title in respect to the suit property. Being agreed, the plaintiff preferred an appeal, which was registered and numbered as title appeal number 02/2019. The learned first appellate before the court of the civil judge senior division Golaghat, hereinafter referred to as the learned first appellate court. The learned first appellate court by the judgment and decree dated 14th of July 2023 decreed the suit in favor of the plaintiff. And it is under such circumstances the instant appeal has been filed. In the backdrop of the above, let us now consider the questions of law which have been proposed by Mr. K.R. Bolwer, the learned counsel appearing on behalf of the appellants, as to whether the same can be said to be substantial questions of law. That as to whether the said questions of law can be formulated as substantial questions of law. Mr. K.R. Bolwer, the learned counsel, had submitted that the learned first appellate court had passed the decree for eviction of the appellant without first deciding the right, title, and interest of the plaintiff. And on mere assumption that the defendants have admitted the title of the plaintiff, which is totally perverse in nature and substance. This would have duly perused the judgments, the pleadings, as well as the judgments passed by both the courts below. From the pleadings of the defendant, it is seen that the defendants have categorically pleaded that the land belonged to the to the plaintiff, and the mother and the plaintiff had delivered possession of the said land in the year 2002 to the appellant number one. And on account of such delivery of possession, the defendant have been, along with his family members, have been residing over the suit land. From the very pleadings, it is therefore clear that the plaintiff, the defendant, have duly admitted the title of the plaintiff over the suit land. In addition to that, this court duly takes note of Exhibit 1 and 2, which were deeds of sale on the basis of which the plaintiff acquired title over the suit land. The defendant, on the other hand, though claimed that there was a gratification of the land in their favor, in his favor, in the favor of the appellant number one. But there is no evidence adduced in support thereof. In this regard, this court finds it relevant to take note of a judgment of the Supreme Court in the case of Maria Marigarda Securia Fernandez versus Erasmo Jack D. Securia, 2012, 5 SCC 370. Wherein the Supreme Court categorically observed that once documents and records of title come before the court, it is the title which has to be looked at first and due weightage has to be given. It will further observe that possession cannot be considered in vacuum. The Supreme Court further observed in the said judgment that there is a presumption that the possession of a person other than that of the owner, if at all, it is to be called the possession, is permissive on behalf of the title holder. And possession of the past is one thing, and the right to remain or continue in future is another. It is further observed by the Supreme Court that a title suit for possession has two parts. First, adjudication of the title, and second, adjudication of possession. If the title dispute is removed and the title is established in one or the other, then in effect, it becomes a suit for ejectment where the defendant must plead and prove why he must not be ejected. Paragraph 60, paragraph 61, paragraph 67 of the said judgment is reproduced hereindunder. In the backdrop of the above, it will be seen that the documents of title of the plaintiff was duly exhibited. There is also no denial that the plaintiff had ownership over the land in question. The defendant, therefore, ought to have produced a better title to non-suit the plaintiff. However, the defendant not only did not adduce any evidence, it is also well settled that pleadings are not proof. Considering the above, the questions of law which have been proposed to be a substantial question of law, which can be formulated, and a question of law so proposed by Mr. K.R. Burwa, the learned counsel, cannot be construed to be a substantial question of law that can be formulated in terms with section 100, bracket 4 of the code. This court further takes note of the judgment of the learned first appellate court, and the same judgment is in tune with the law settled by the Supreme Court in the above referred judgment. Considering the above, this court finds no ground to interfere, no ground, and finds no substantial question of law that can be formulated in the instant plea for which the appeal stands dismissed with cost.
Eleven.
Yes, Mr. Sattar. You took time on 5-3 and it again had landed on back to me. Yes.
My lord, in my respectful submission before your lordship, only one substantial question of law, whether at page number 11, my lord,
Huh?
at page number 11 of the book,
Which one?
that is, my lord, whether the defendant number 1, 4, or the respondent number 5, whether they had the sellable right to sell 4 katta of land to the client.
You are the defendant number 1.
I was the defendant number 5, 5 and 6.
2 to 4 could have sold.
1 and 4, 1 to 4 are the proposed seller or seller of the plaintiff. Plaintiff have filed the suit for declaration and recovery of possession, saying that at the behest of the defendant number 1 to 4, the possession was given to the defendant number 5 and 6. So they want plaintiff want recovery of possession from me, my lord.
5 and 6. Now you are challenging
I am challenging.
the sale deed.
No, I'm not challenging. I'm challenging that they had no right to sell 4 katta of land. Only 2 katta, 2.5 katta of land was 40 years.
So you challenge the sale deed.
Yes,
You had a counterclaim.
not by the counterclaim, by showing my own sale deed, which was of the year 1985 and 80.
48.
Yes, yes.
You are coming under 48 of the Transfer of Property Act. But without challenging the sale deed.
I'm saying that the sale deed to the extent of 2 katta, 14.5 katta may be correct, but not to the tune of 4 katta. Because
And how does the first appellate court look into it?
The first appellate court, my lord,
First, where is your pleading?
at page number 24, my lord, paragraph number 4. That is my written statement where I have taken that plea.
So, number 4, paragraph number 4. Where the issues?
Issues are at, my lord, page number, uh, my lord, page number 32.
Number 2.
Yes, my lord.
Exhibit B is unregistered.
Exhibit A is registered, exhibit B was, my exhibit B was on there.
So, by which you have been purchased? You purchased by the
By
exhibit A,
exhibit
how
A.
much? No, what is exhibit A?
Exhibit A is my sale deed, my lord, by which Madhav Das has sold the property to me in the year 1980.
How much?
2 katha 50 lakhs.
That's the first appellate court.
My lord, the first, if I can take your lordship for that question, I mean, for that issue, it is starting from page number 50, 55, my lord. Issue number 2 is the form of, my lord, points for determination. And categorically, my lord, at page number 59, the first appellate court has ruled that this issue was not discussed in proper. Yet, my lord, the
Let's see exhibit A. Who exhibited it?
The sale deed.
Exhibit A.
Exhibit A was executed by my lord. Half of the shareholder, Madhav Das, who is the son of Sukhna Das. My
Which
lord,
Sukhadar?
yes. My lord, here, 4 bighas, 1 katta, 19 lecha of land was the total land pertaining to Dag number, my lord, 619. There was only one Dag containing 4 bighas, 1 katta, 19 lecha. Two persons were the inheritors of that property, my lord, and each were entitled to 2 bighas, 19 and half lecha. 19 and half lecha. Sukhna Das is one amongst them. One in between them, Sukna and Rangbal. Now, my lord, Rangbal Das had 4 sons, and Sukna was also having 4 sons. So each son was entitled for only 2 katta, 14 and half lecha of land.
Where we mention in a written statement all these things.
My lord, at page number 24. Page number 24, paragraph number 4, my lord.
Paragraph number
4, my lord.
4 is different.
4, that the plant is not maintainable in view of the
But that
life
is
of-
okay, but where you mention about this Sukna Das and all these things, 2.5 letters they nahi hai. Where you mention?
No, that, my lord, the plant is self-plant.
Where you mention all this? First of all, this is a concurrent finding of fact on the exhibit A. There has been a violent challenge to deed of sale.
Because they had no sellable right. Plant.
Therefore, you have to challenge it.
My lord, that's what I have mentioned in paragraph number 4, my lord.
But you have not challenged the deed of sale.
Deed of sale, in that way, my lord, challenge that they had no right.
No. You have to challenge the deed of sale. It is not a void document.
No, it is not a void document, my lord. That area of the land which was sold in excess is to be reduced. That much only.
No, understood. But then also where you challenge the deed of sale? By the deed of sale, 4 kattas of land has been sold.
Yes,
See, Jivan Das got 4 kattas of land. After a partition, this is the evidence.
my lord, he got only 2.5 acres.
That is you are saying. But from the evidence which is being held by both the courts below, the Jivan Das after partition had 4 kattas of land. This was duly inserted in the mutation entry number 76. And thereupon the names of these 4 persons have come in respect to these 4 kattas of land which was transferred by the deed of sale. This is the finding of fact. Now, if that be so, how does exhibit A fit into the scene?
Exhibit A, my lord, is the,
Unless you show that your boundaries are these, it is within these boundaries, so therefore the sale deed has to be challenged.
my lord, that is their requirements, but there is no such partition amongst them. That was only one, my lord. Containing 4 bighas.
You are saying that no partition is there, but the question is, there is a finding of fact that there is a partition.
Yes.
Then,
That too without, my lord, any document for the learned trial court as well as,
no, on the basis of that, they are giving this evidence. This is what the first appellate court
my lord,
printed.
but he is also admitted in the.
And you could not break anything in the cross. This is what has been stated. Both the witnesses categorically stated they have right title and interest over the 4 kattas of land, and they have transferred the favor, and it was going to partition of the Iman. The learned counsel is submitted as so and so. Then it says that right after the names were mutated, they eliminated the suit land in favor of the respondent number 1 by the deed of sale bearing deed number so and so, which has been exhibited in exhibit 5 in the suit. As the suit land was transferred through execution here, which requires permission to be obtained and so and so. In such a the execution of the sale deed in favor of the respondent number 1 cannot be challenged merely on stringent grounds. Now you have not challenged that sale deed.
My lord, in the evidence, while cross-examination, my lord, they themselves have said that may be permitted to.
Hmm.
I do not know the amount of land inherited by Jivan Das, Jagmal Koj, Jairam Das, and Rangmal Das. It is true that Jagal, Jivan, Jairam, and Rajat are not entitled to inherit 2 katta 15 lecha of land individually, from their father Rambal.
It is not true.
Yes,
It is not true.
so it is true.
Ah.
It is true they have said.
That
It is true that Jagal, Shivan, Jairam and Rajat is entitled to inherit 2 kata 15 lacha only. 2 kata 15 lacha of land in individually
Show
from
me that
their
evidence.
father Rangmal Das.
but the problem is the silly. Who's Gopidas? TW1.
Gopidas is the plaintiff mother.
Wow, how will the plaintiff know this?
Because he,
No, how, whether he says or not, that is immaterial, but whether the defendant, those defendant numbers 1 to 4, did they say that? Did you confront that?
they are DW1 and DW2.
They are the purpose people who have sold it. We have not challenged the sale deed. This is what I'm saying. That is why the matter escaped last time 5-3 and again has landed back into my hands.
That's what I prayed for that. That it
Huh?
should come before your lordship for that proper adjudication that they have made. I prayed for that to come up before your lordship because for the proper
Because that is the main problem which I have been asking you last time also. Why haven't you challenged the sale deed? Without the challenge, it is a raise the document. Unless it is voidable, you can obviously show something else. Then did you raise the issue of 48? No. Nothing is there. And I don't understand one thing. Why Exhibit A? Can you have a copy? Let's hear you at 2. We'll hear you at 2. Kindly get out the Exhibit A. Why Exhibit A question? And if there was a sale in respect to whether it is the boundaries, because if it was a bigger block of land,
yes.
some portion was sold by somebody, some shareholder.
Yes.
You say that that portion falls in the portion of these 4 kathas.
No, no, my lord. That the unregistered sale deed, which is Exhibit B, that falls within that portion.
Then what is your right for Exhibit A?
Exhibit A, I am having the absolute ownership over that.
But does Exhibit A land falls within the 4 kathas,
Yeah, no, within 4 bigha, 1 kata 19 lakhs.
which has nothing to do with the 4 kathas?
No, my-
So that is why Exhibit A is not so discussed.
Yes,
Exhibit B has no relevance.
but I am having the position of that, my lord. Since the year 1985.
So,
And the present plaintiff has purchased the land only in the year 2007. My lord.
so what? Who sold you? Hindu?
No, my,
Hindu? Hindu people sold you.
my lord,
Well,
it's Jivan Das actually,
so Jivan Das is Hindu, I am supposed. So obviously, Mohammedan law would not come into play.
here go. My lord,
Okay, we dismiss it.
Krishna Patwari
Let me
is the
come back
particular-
at 2 and dismiss it.
My lord.
Yes, Mr.
kindly allow 2 weeks time.
But exhibit A has no relevance.
Exactly, my lord, because that is unchecked,
So exhibit B is the question. Exhibit B is the unregistered document.
unregistered. That's correct.
Mr. Disappointing. And now discussing and deciding the saleable right vendor that is dependent upon one to four based on the evidence led by the party. It's a great question. The substantial to take a convenient party with uh, nine of the seven second village which under the Hatu out of the land to become one kata 19 lecture in Pakta. 20,000. I think that 5 and 6. I could persuade the plaintiff to transfer the said land to them, which the plaintiff refused. And thereafter threatened the plaintiff that consequences as well as the plaintiff land. The case of the plaintiff that August 2010, plaintiff was possessed with the defendant 5 and 6. Thereafter, the circle of the Hadro by order dated 6/10, literally, arbitrarily cancelled the litigation. By the by guideline, first, yeah, valid and binding. We have passed the things can make it consent. They were and again. As well as that some I think 6 file the state wherein their specific attention taken is that defendant number 1 to 4 has the right to have the right to transfer of the land favor of the plaintiff in as much as necessary interest right over the have to keep the half acre of land in favor of the five. That denied the title of the plaintiff. Defendants denied the title of the plaintiff and sought for dismissal of the suit. On the basis of the plaintiff, basis of the pleadings, the learned trial court has claimed and framed 5 issues which, being relevant, are reproduced when we done the page 32. The issue taking into account the on behalf of the plaintiff, he examined and put square on behalf of the defendant, five witnesses were examined, 6 documents were listed. For the purpose of deciding the question of law, which are that will be pushed by the learned trial court. The learned trial court, taking into account the evidence of the court, and more particularly the evidence of the court, more particularly exhibit 1 and 5, which have been proved in origin, came to a categorical finding that the plaintiff has ownership over the suit land. Which is very pertinent also to take note of that the learned transport can also take a note of the categorical stand taken by the late defendant number 5 and 6 to the effect that the predecessor of the defendant number 1 and 4 had already eliminated two kata 14.5 letters of land to the defendant number 5. Categorically taking note of the state case of the defendant, the effect that the predecessor of the defendant was 1 to 4 had eliminated half letter five and came to a finding that the version of the defendant number 5 and 6 that the predecessor of the defendant number had sold two of a to the defendant number 5 cannot be said to have been proved. Paragraph 8 of the said judgment of the learned trial court being a finding of fact, being an analysis of the evidence and the finding arrived at in respect to the same issue, which is pertinent to the question of law proposed is reproduced during an If you further see that the learned trial court by the judgment and order dated judgment and receipt dated 28/2018, it is in favor of the plaintiff by granting the relief as was offered. We agree the defendant number 5 and 6 who are the influence hearing to pay the number of the learned trial court have also the learned first appellate court by the judgment in the dated 29th of November 2024 dismissed the said appeal. Pertinent to mention that the learned trial first appellate court also duly dealt with the state contention of the defendant 5 and 6 as regards a sale being made in favor of the defendant number 5 by the predecessor in interest of the defendant number 1 to 4 and observe that the findings of facts observe that the state that that the plaintiff has the right title interest over the land described in the schedule below, schedule to the claim. Which paragraph, the observations, the findings of facts cited by the learned trial court for first appellate court at paragraph number 24 and 25 being relevant for the purpose of the instant appeal is reproduced in under. We agree the present appeal has been filed before this court. And the question which arises and the question of law which have been proposed being agreed, the present appeal has been filed. The issue which arises for consideration before this court as to whether the questions so proposed by the learned counsel appearing on behalf of the appellate can at all be related to the substantial question of law. In the following paragraphs of the instant judgment, this court has duly taken note of the finding of fact cited by the learned counsel in respect to the question, in respect to the question so proposed by the learned counsel appearing on behalf of the appellate. The said findings of facts have been concurrently arrived at by the learned trial court as well as the learned first appellate court on the basis of evidence on the court. And on the basis thereof have come to a categorical finding that the plaintiff had right, title, and interest over 4 acres of land. These concurrent findings of facts without their being controversy cannot be interfered with by the second appellate. It's a well-settled proposition of law that the findings of facts sense any perversity cannot be interfered with in the second appellate stage. This court further takes note of that the deed of sale on the basis of which the plaintiff have claimed the right, title, and interest over the suit land have also not been challenged by the defendant number 4 and 5 and 6, who are the appellants in the instant proceedings. Considering the above, this court does not find any ground. It is of the opinion that the instant appeal lacks merit and the substantial question of law so supposed cannot be stipulated as a substantial question of law involved in the instant appeal. So accordingly, this court finds no merit in the instant appeal for which the instance is dismissed. However, in the facts of the case, this court is not imposing any cost.
Well,
Yes, Mr. Ivanov.
Yes, the trial court has dismissed my suit on the issue of the 4 and 6. While trying the appeal, my lord, the London appellate court did not have any other issue except now 5. So that is my view. That was the issue that we did. And on that basis, my lord, it is that. No other issue has been done. Right, ma'am.
Then the suit is brought by res judicata.
That was on the one ballot. No other issue that is. That was decided in my favor by the trial court and now the appellate court has decided. When it was of the earlier suit, the lawsuit fine, my lord, it was only in respect of 2 rules. my lord.
You were a plaintiff.
Huh?
You were a plaintiff.
I will.
You were a plaintiff.
Yes. I will.
So you were a tenant,
I will. Yes. Then it's non-applicable.
non-evictable tenant under the performer defendant. Now, what has happened? Their defendants wanted to evict you.
Then it's filed a suit, my lord, in respect of 2 rules. To that. Now.
Two
we are
rooms
in-
are too dark.
Hello?
That big, too big, 2 rooms are too small. Which one?
To that. 2 rooms in to that. That is the suit, my lord, and I put the date of the earlier. The earlier matter is also pending.
Huh?
The earlier matter is pending.
What was the earliest suit for?
Earlier suit was for addition bed with a plain mother. Addition of two rooms was one bedroom, 16 by 11 width, and another bedroom was 50 by 11. Shall two. It will your
Are you in a position to read it properly? Mr. Savila, are you in a position to read it properly?
that's the mother, that's the mother. But that is mother, that one bed.
Mr. Savila, let your junior take some pain, type this out and place it before me on Wednesday. Yes, the matter.
So when was the, I have a copy of the, the, that's the, only the document.
This is a suit filed by,
And by the,
by your tenant, by your landlord.
no, no, but, yeah, the one, like, of the house.
This is by landlord and here, how res judicata will apply?
That is not what the question. There's no question of gratuity.
Because this is a suit by borrowers against Bori firms. That is you. What is the suit for?
It's for eviction, madam, that as a, mother, the employee, mother, they will be in the room and we are not. Vacating. They say that was working as a peon, and that is why he was able to.
Who are you?
Only one.
And who are the others? One,
Yes,
two, principal defendant? Isn't it between the same parties? Res judicata?
Same party, but this is the set of food only. And the ground is that, mother, as an employee, mother, they do to elder to us, mother, and they want.
No, for application of res judicata, it has to be between no suit either has been tried directly and subsidiary in the former suit between the same parties.
Same party, maybe, but.
Or between parties under whom they are, any of them claim.
Yes.
Now, these principal defendants,
Yes.
this present suit,
Yes.
are not claiming under this borough, this, what is that, Borough Memorial Christian Hospital Society? No. They are not even a party here.
No, they are not.
Are these people claiming under them? Son of promote manager of, number one is claiming. Oh.
Usually, mother, they just belong to somebody else.
Hmm?
But belong to that,
You have leasehold over what?
these are the ones and then, madam. Hotel owners, they give me the lead. And we
Because
come,
see that she will get it one.
and the food land is also, madam, you are looking to see that, yes, darks are there. Many darks.
What right to? How is that?
Darks are there.
It is a case of remand. Don't you think?
Yes. It is a. Well, the water program, beside all the.
Pass the impugn judgment and the date 16/12/2000 that living but the date of the that the grounds of objections, all the grounds of objections taken in the memo is required to be decided. Text with the yes, take this. Arvata code whether the number justify justified or citing the question of the adjudicator in as much as parties parties to the suit entitled to come to students. What is the that suit? That suit 24 of 1996. Different was different when the parties to the suit entitled to come to the 1996. Different from parties entitled to 1996. Started
Directed to the steps.
which one
Okay.
you are
I put a claim.
what happened? You're asking for a higher amount?
About a, I can see this was dismissed.
Why? Why was the case dismissed?
This cut.
Who are you asking the money from?
Martin Hanlon.
Huh?
Martin Hanlon.
Marty van entered into an accident
Yeah.
with two trucks.
Vehicles going.
Is it your evidence that the Maruti van was driven in a rash and negligent manner?
That was not true.
Then how do I help you?
Okay.
How?
There is a liability lawsuit.
Liability of what?
That one.
How? Unless there is a rash and negligent driving. Can there be a liability? Just for example, you are there in the Maruti van standing out there, two trucks come and collide. How do you do it? How did the insurer of the liability, insurer of the Maruti van, can indemnify? Okay. And you are person claimant died. Who are you?
Okay. His wife and suffered
Huh?
the claimant. Claimant of,
Who is the claimant?
he was injured in the accident and later on
He died.
now that was the
So initially it was a injury case. Then it became a death case. Because in the agony of the clients, whether it makes sense. Let me see what can be done. You have not stated anything. Who is Lakshman Roy? PW4. Here the might say paragraph 5 of the evidence. Oh, you are not prepared. Then I beg to say that the said accident took place due to rash and negligent driving of its owner, Nishan Mohan Nahata, who was driving the vehicle at the relevant point of accident and could not control the vehicle and collided with the two trucks which fled away. Now, what is the evidence of, because the person who was there, na, Jagadish Brahmin, very difficult to read. First, Kumar Chaudhary, the driver of the Maruti van, drove the vehicle with right speed and in the right direction. So you have stated in your speed. Cross, you said the other way. Well, I think we should stop the beginning. Unfortunately, hard to finish. Hard to finish. Balance, na? Huh? So getting up. One, two, and three. And if you up. Big challenging the judgment and then take it. Second, well, past the case to one with and like it. The stress. Facts of the incident proceeding. Facts which have led to the incident proceeding. On 21, 26, 12, 1991, the case, uh, the basis of the claimants along with the British government. It seems to see one day IFS Kumar gave to Raja and Sri Mishra Navata. Governor Marty Well under AS Steve 789. The same Maruti van met with an accident son Vidar Mia by the railway down on National Highway number Q. Uh, necessary list of the claimant date whether this was injured, resulted in injury, resulted in fine and we find a claim proceedings being MSC case number 123 of 1994. The state proceedings in Jagadish Brahmin expired and the state proceedings meaning the claimants. take in proceeding. Uh, take in third of the multi-event as well as the issue of the multi-event that is the where to make it needed. It seems that the take claim proceedings were initially disposed of by the judgment and order dated 2/6/1997 by the learned member MSC Bodaiga. During a subsequent record by the Liverpool, this court had remanded the matter back to the learned member learned tribunal for fresh disposal. On the basis of the basis thereof, of no additional issues were named apart from the two issues were named, the originally named two issues. On behalf of the claimants, witnesses were examined and documents were exhibited. Half of the only part ensure evidence was used. The limit criteria required other data. Judgment and order reward dated 21/7/2000 dismiss the safety proceedings. Primarily on the ground that the multi-bank in which was not the offending vehicle and offending vehicles with the trucks who could not be, who were not made party, uh, trucks with which it is seen. The question therefore arises is proceedings as to whether this book which required to interfere with the improved judgment and is more dated 21/7/2012. This court had only taken note of evidence with the two who categorically mentions evidence of improved during the cross-examination that categorically mentioned that the driver of the Maruti van drove the vehicle with right speed in the right direction. Three. The two also stated that the two trucks which were involved in the accident could not be identified as the two trucks fled away. It's taking into account that the Maruti van in question was not the offending vehicle as also held by the learned member MSC. Why the question of imposition of any taxation upon the respondent number 2 and 3 names to proceeding, upon the respondent number 1, 2, and 3 names to proceedings does not arise. According to school function merit to the instead for which the expertise has expressed.
That's set for paid.
So madam, this way, that way, you are just something. Huh?
Only time we get in the
Why?
We have to file immediately.
So why haven't you taken steps upon respond number three? Who is respond number three?
We have taken on.
Wait. Who is respond number two? Owner come driver. Okay, now why are you challenging it? What is your ground of objection?
There are two men. By the company report of and some blank cover note which they wrote by the company and among such a cover note.
Have you paid the money or not? Have you deposited the entire amount or not? Huh? We can't wait for these matters to be paid. But the appeal been admitted, appeal has not been admitted. Huh? What notice? What is this I stay is given? No. We don't have jurisdiction. Can in an appeal, notice be issued? Let us hear from you very important fundamental question. Then, without admission of the appeal, we don't get the jurisdiction. Then, stay in business, we have not paid that amount. Deposit that amount, we admit that otherwise we dismiss that. What is this? 2016 have not yet been admitted. No. Interim order has not been extended, pending return of notice. Therefore, you are not taking steps.
You've taken on
No,
22, 9,
return, the trustee service upon response will be taken within 2 weeks. Nothing has happened. Appeal has not been admitted. Pay that amount. We stay subject to paying that amount, like 87,000. Is an appeal filed under filed with the administration. The land council appearing on behalf of the appellant. It is noticed that though the appeal is previous to the records do not indicate that the appeal has yet been executed. Taking into account the ground of objection to the plaintiff, the instant appeal is admitted. Also, the records steps be taken upon the one and two. One and two. Two. By registered as well as mutual. In addition to that, and is also directed to effect service upon the respondent number 1 and 2 by way of trustee and trustee. And an application. Also the records to do. This matter again on 2nd of June 2025. You have to take your steps immediately. An application filed under order 41 rule 5, the code of civil procedure, state of the judgment and decree. Award dated 7/9/2015, passed in MEC, passed by the member MEC team Murigaon at Murigaon in MEC case number 6/10, whereby an amount of rupees 1,87,000. Much? So rupees 1,87,088 have been settled upon the respondent upon the appellant along with interest at the rate of 6%. At the rate of 8%. One lakh 81,000, 87,808. 87,088. Along with interest at the rate of 88% in final realization. Taking into account that the instant appeal has been, the accompanying appeal has been admitted and fixed for a year, admitted. The judgment and the judgment and award dated 7/9/2015 passed in MSC case number 66 of the 2010 by the relevant member. Basically, Origam is state subject to deposit of the amount of rupees 1,87,088 before the registry of this court within 6 weeks from the date of the instant order. Okay. This court further grants liberty to the respondent number one who is the claimant to file an application before the registry for release of the same amount and upon for verification. To the point, why you have filed it?
In order to the 9/4/2018, there is an instruction, my lord, we have to take instruction regarding the WS we have file or not. My lord. We have not communicated, there is no communication between client and this long back. And the respondent is already submitted on that day, the WS has already been filed. Accordingly, madam, matter has become referred to us today, if the WS has been filed. Case has been completed expert against us. Find the modification number 2, the main statement.
No state.
Even trial court, because I have seen the last order in the trial court, madam. Plaintiff has also not appeared in the trial court, madam. Court notice has been sent to the plaintiff, madam. It is fixed on 19th of May, 19th of June, madam, the trial. It is at the stage of statement and permission. The trial. Right now, the trial court.
You are the performer. Why are you delaying it? And you died. Who died?
Time. Respondent of the time. I think the sentence are already defined. I don't think it is that is that is the time sometimes is from 7 prior to filing of this. Subsequently, final standard and not up. That's some of the issue on 24, 3.
Well, like, You are the performer defend number?
Reflected as condition number 3 matters. My lord, kindly produce page 57, my lord. If my petition, I have got time for filing my written statement. In this petition number also is there. Sorry, it is condition number 3. And this is going to find the money.
And where is the summon served? What, what?
Paper may become resource. The response number 1 is something to take the instruction of the order to the 9 before making.
One. You were that big. They made it two. But everywhere they have utilized so-called dependency. He gains the in the sales. Other to that, the period of 90 days having been over and the statement having not been filed, this could be or justified in rejecting the application in filing the statement. Taking the application seeking further time for filing the statement. Considering the above, I against the opportunity unelected 17% impact through number 25 thousand divided against seats.
Sixteen,
Maybe as the XCR has also XCR having been received and this morning being presented. He listed for hearing and that we will cause liberty given to the parties to file application. But I have not. I for what? I I did no order. There is an order. Yeah, 20,000. What is the judgment for? It is for eviction. and dated 26 9 2016 absolutely hearing state in disposal of the past entitled if you not become in by the court of the learned judge elegantly a state of eyes.
17,
Main feature of it. So now we have 5G affiliate guys
Repairing?
or as to know what
Please respond number 4.
now it comes driver. Now it comes driver.
The service is complete.
Yes.
Fix it for hearing. Taking into service complete. Offering that. LCA living business. LCA I can. Yes. LCA living business. Here, receive.
Yes.
Receive. That is a bill pay is for hearing. In the usual course. The parties. I have to be. Service complete.
The engaged person, Mr. K.K. Datta is not available to.
I'm not concerned. Is the service complete or not? Service complete. Service complete NCR having been received, it's the matter for using the report will be given to this party to file. Unit
19,
service complete. Service being complete in the NCR having been received, it's the matter for repeat hearing in the usual course.
20,
Service complete.
I will complete the number one guy. Just had a fill it out. I made a process. And we could, that's what is appeared for respondent, but only one. That's that. We'll kind of cut down to one.
So anyone wonders?
He's not with here.
The service is complete. Service is complete and the LCR having been received, it's the matter of the hearing in the usual course, they will be given to the parties.
21,
Service complete.
service corresponding to service has not been prohibited, but he has died.
Who is respond number two?
This respondent number two. So I have just received
Who is respond number two?
Vishnukanth Bora,
Owner of the vehicle.
owner of the,
You are the insurance company.
right?
You are who?
The owner of the,
Who are you?
I am the appellant.
Appellant means claimant.
Claimant.
And why you are fighting against the owner?
The order, is it's like that insurance company will have to pay and realize the amount. Order. That's why
Now, why have you filed the appeal?
I'm bidding for announcement of the award.
So have you filed the application for substitute?
My lord, please give time for
After appearing on behalf of the appellant submitted as a responsible to the owner and
the death certificate.
I said sometime we be granted to be. 4 weeks time is granted to do the needful.
Fifty-two. I think 52.
Yeah, okay. Yes, yes. The office will dated 4/6/2024. Seen with the service of the on to service. Also seen the LC and the considering the appeal will be given part of filing application. Otherwise, appeal.
23.
About service, it seems that the service LCL has not yet been received in spite of requisition being made. By the spot, by the race to the spot, by the spot. Race shall take effective steps so that the history of the LCR is received at the earliest. Taking into account that the services will be complete to reach the matters of the course. It will be given to the parties to file an application for after the reports are after ascertaining the receipt. So
24.
This upon the respondent number one is to take, with regards to two, four, whether I am going to, I have filed the two
2 and 4.
to four will have to take step by step, because the address seems to be,
I think it.
report has come that the address from there, they are not living in the same area.
Who is 2 to 4?
So for respondent, so for dependent.
Performer? No. What do you need?
The people they are dependent, but, one, two, four and five are the,
No, he was the dependent.
yeah, dependent appellant.
Dependent appellant, so he has no quarrel with the defendants. You have a quarrel with the defendant. So for him, he is the performer. Then how do you going back out the name?
Let's say, the report was not called for any kind of violation.
Report will call for approval. You seen the service upon the respondent number 2 to 4 is not complete. Received from the officer that the service upon the respondent to 4 is not complete. However, it is also to be noted that the respondent number 2 to 4 are performer respondents. It's the P.K. Bhagwati, the council submits that is the performer that students have no issue with performer respondents. The name will be struck off. Taking into account the above, the names of the performer respondent number 2 to 4 are struck off. We've also taken note of that although by the order dated 7/6/2024. By the order dated, by the order dated 7/6/2024, the appeal has been admitted by formulating a substantial virtual law. However, the local reports LCR have not been found. Taking into account that LCR will be required for the proper education of the institute, the case we shall take steps. Only for the way the LCR all ways which will take effective steps for bringing on record for reconditioning the LCR. Taking into account that the services which the matter of the usual courts, they will be given to the parties to file the application for early hearing after ascertaining the receipt.
Okay. Stay there. Stay was not content because of the other side.
Huh?
Stay petition was, stay was not content.
Right.
It was to be considered in the name of.
Not
Very
granted
clear
because of the
Because
fact
of the
that when the
problem has come
matter,
up.
when the appeal came before me earlier, I did not formulate that question. What is the appeal? What is the appeal? It's okay. What do you require? No, understand.
Only thing in view of this.
No. Nothing we,
In case they finally will up.
no. What is that? They have a right title interest over the food land. Being declared good,
They cannot approve and reprove because at the earlier so they said that
whatever may be, this is the decree. The decree says the right title and interest of the plaintiff over the suit land is hereby declared. Number 2, the defendant respondents are hereby restrained from entering into the suit land and from disturbing the possession. Rightly so. We dismiss your application.
Lordship is that once it
Dismiss.
is admitted.
No. Appeal is admitted, so what? This is the which if an appeal is admitted, normally if you were the other side, if it was his appeal, he would have asked for an injunction. Isn't it? And this court would have granted him an injunction, not to disturb his possession. Isn't it? Now you want that we vacate that injunction and allow you to disturb. No. No. Mr. B.K.
In the event,
No, in the event. There is no in the event doesn't arise. You are not to disturb. All right, Mr. Vicky, Bhagwati, the council appearing on and going to appearing on the with an application filed under Article 41 the code of civil procedure for stay of the appeal judgment in appeal dated 1/12/2023 past 10. Title appeal number 5 for 2022. This court have duly taken note of the direction so passed in the impugned judgment and decree, whereby the Limit Tribe First Appellate Court had declared the right title and interest over the plaintiff of the plaintiff over the suit. Further to that, this court, the Limit First Appellate Court had also restrained the appellants, the respondent, the defendants who are the appellants hearing from entering into the suit land and from disturbing the possession of the plaintiff, who's taking into account the directions which have been passed by the learned First Appellate Court and the decree which has been passed by the learned First Appellate Court. This court finds no ground to exercise its jurisdiction under Order 41/5 to stay the impugned judgment and decree. Considering the above, this court finds no merit in the application for which the application stands dismissed.
25.
Yeah, what it is, a certified copy of the registered deed of sale is not admissible in evidence for the purpose of proving the contents of the fraudulent title deed. In view of the before you there be 55 things. What is that? What type of question is this?
Whether this question of law, in fact, we want to remember that thing of transfer from one trustee to another trust, same thing, which was there. It was produced in certified copy was produced, that was rejected by the trial court as well as the first appellate. So the trial court,
Oh, same type.
said
I have formulated the question.
in other case, and in this case, order 41/27 was filed twice. Those were rejected, and in trial court also, one application was filed for following the strategy step. That was also rejected, saying that in the record of the trial court, that those applications were not found. That,
LCR has not been received.
so why not only title the deeds?
We seen from the office note that in 9/4/2025, the LCR of citation number 145/94 have not yet been received. The registry shall take effective steps for requisitioning of the LCR. It also to be noted that the respondent, that the service is complete, is to take into account the above is the matter for hearing in the usual course. Also liberty given to both the parties to file application for early hearings after ascertaining the receipt.
26.
So,
That is complete. 1 and 4 expired. Who is 1 and 4? Who is 1 and 4?
yeah, fine.
Who is
One
1?
of the plaintiff number one was she, number 4, one, the mother of
So you are paying for one is there, and which five, four, which four,
And four also without, cover.
so not necessary. Mr. Soin,
Mother of the restaurant of the five. Adopted. Five will be adopted. So, they will. I just, so there is no cover. For,
I will the adopted son.
yes.
Then why not surviving?
Sorry, it's already.
So therefore not necessary.
Going others to like.
Mr. So the Learning Council is hearing on behalf of the respondent number 2, 3, and 5. Submits that respondent number 1 was the mother was the mother of the respondent number 2, and respondent number 4 was the mother of the respondent number 5. Taking into account that the the estate of the respondent number 1 and 4 are unique, represented by the respondent number 2 and 5 respectively from the system. There is no requirement for substitution upon the death of the respondent 1 and 4. It is further relevant to take note of that, that the LCR of title appeal number 1 of the 2022 has not yet been received. The registration notification, the state appropriate steps for regulation of the state LCR of the number 1 of the 2022 from the learned court, learned first appeal court. To this the matter for hearing in the usual course, we will be able to go there after ascertaining the procedure.
37. Like the last order, notification respondent number 1 is not start, but it's divided. But 2 and 3, refuse to accept the notice. So that is presented start.
Who has received 2 and 3 are who?
2 and 3 are, they are the brothers.
Of respondent number 1.
Respondent number 1, 1, 2, and 3, all are the brothers. But 2 is the brother not from the same mother. Not from the same mother.
So what to
So,
do?
with respect of 1,
Family refused, member refused to accept the notice on his behalf. Wouldn't it order 5 rule 17 come into play? Order 5 rule 15?
no, there is the order for presumptive staff. Can you say 11, 12, 24?
Continue. No, I'm saying about response number 1.
Yes. That is
When
not
the
yet done.
family members refuse, when there's an adult member in the family, then obviously within the service be of the done.
That could be presumptive staff, but in the view of section, 5, rule 9, of order 5, rule 9 of the, that will also presumptive staff.
This court have duly perused the office note dated 6/9/2020. The registry. Let the matter be listed before the laws of the court. And the registry and the laws of the court shall ascertain in terms with the Code of Civil Procedure 1908 as to whether the service upon the responding numbers 1, 2, and 3 can be deemed to have been served, taking into account can be deemed to have been served. Registry shall be-
Well, it is already served by the court, but the largest order, court will do. Already court have presumptive staff.
Court has passed an order.
Yes, that is the, can you say 11, 12, 24? So it's very confined only up to, I don't know,
Twenty-eight. What about response number 4? Huh? The service upon the response number 2 and 4 is not complete. It's the matter of the completion of service. 29 and 30. You want to withdraw? I'll send further and counsel appearing on behalf of the petitioner in both the revision application submits that he has instructions to withdraw the instant petition and amicable settlement. Legal. Taking into account the above, the instant petition stands closed and withdrawn. Contain model continues. Repeated. The model of stay is there. Thirty-one. Think that the office is think the service is really complete. Also, however, the NCR of A number 18 of 2021 has not been received. Taking into account the above, the registration and information for recognition of the NCR of A number 18 of 2021 earliest. It's the meeting for hearing to be written for liberty given to both the parties to file appropriate application for early hearing after ascertaining to receive the request. 32. Item.
So this is complete. So correct number 5 is here.
Service is complete, NCR having been received, it's the matter for the cost and the for final get application for you. 33. Six nine. Phone number 69. Tapo. 33. Secretary, how is the secretary cannot be died? Can the secretary die? Huh? What type of office must be? It is the office. It's not. This court have duly taken note of. The note dated 7/4/2025. It showed that the respondent number 6 had expired. However, it surprises the score in as much as the respondent number 6 is a society. And as such, the said society, and the said society, and as such, the said office note dated 7/4/2025. In the case of it possess, considering the above, the petition lieutenant Levin is directed to take fresh steps upon the respondent number 6 by registered as well as usual. You want to strike out? Why? You are the plaintiff. You can't strike out. You cannot strike out. It will have the implication. Because they were the defendant, not performer. Can't strike. If strike out, then if I pass a decree in your favor, then in that regard, that decree would not be operative against 6, which will have a repercussion. You take it by the state. But for personal the petition, the appellant herein is given the is directed to take steps on the respondent number 6 by way of the state. And related to the registry of this court and file affidavit of service on the state. Is the matter again on 4th of June 2000. What is this IA state? State. You were asking for an injunction. We got an injunction. You are in possession. Both the suit, trial court and first appeal court, concurrent. Concurrent. I one of the court. Mr. Q will also the legal counsel appearing on behalf of the applicant seeks for submits that an interim and an interim injunction be passed. This court has been taken the problem is not referring respondent number to 1, 2, and 1, 2, 3, 4 are not presently in spite of their names being shown in the courts. For the ends of justice, this court directs judge the judge instead application shall be considered on the next day for disposal. So, in the meantime, till the oh, this case. The meantime, not this. Oh, like. Article. Service complete with the map of hearing. And you will be given for filing application. Of the parties.
Therefore, 1 week. Other consent.
Right. What is this IA business?
I have to take.
To find your objection.
I have to. You said it's not a big. modified the exit performance becomes performance. Money is to be refunded. That is understood. So I am ready and pay for the target. But money, so there is a responsibility. If I don't pay the money,
Why you are not a employee under 24?
I have filed a brand new the 24. Yes, but that no order has been passed. In the meantime, they have been done.
People.
By this,
Cannot be.
I filed not only I have filed a but along with check I have.
There is no stake.
Yeah, there is a statement of disposal of file.
No.
Yes, yes,
Email Roy.
yes.
You file an I.
So the for the demo file, the
Who is he? Who is he? Third party or owner?
owner. So owner. My only appearance is that you can accept the contract. But that is created. And one
You
of
file your objection if you have to any. And when you are going to do it, next week.
next week, I know
This is I 877 2024. I think. Mr. SK code, if everyone half of the responding, of which that you would like to file an objection. This with hearing on behalf of the applicant expresses urgency to taking into account the law. This matter 38th of April, 2025. It observes that if no objection actually filed on or before 28th of April, 29th of April, 2025, on this court shall proceed with the interpretation of the injunction application on the basis of the NCR will come later first.
36.
What is this tail number? And well, That case. These are not substantial questions. Why do we need the reports?
Another question of that.
Another case, this case is no case.
I would say 180. I think.
Let me,
One is, one is for,
why should we trouble the other side in appearing?
one is my lord, for switching the counter claim. Another is, for fixing the. Right. 180. Just a matter of good.
Which one? Number 180.
One.
This one. This the instant appeal along with RAC number 180 before on that date. Second of May. Okay. 37. Yeah. Service thing can put.
I may be allowed to go to.
Yes.
Wait, just a minute, admit it. That's not fair.
Earlier one. Yeah, go to something. From the reports that it's an appeal under section 100. The Code of Civil Procedure 9. The jurisdiction is vested upon the court only when there is a substantial question of law wrong in the case. However, given that they will show that the extent yet to be different. Mainstream shall fix the matter.
Thirty-nine.
If the appeal be admitted, admitted. That's the. LCI you feel. So I admitted it, yes. I think. You're appealing?
1A and B.
What is this? 1A and 1B. But nobody else. Only two. Service is complete. Why? Why is it not complete? 1A and 1B. Please, sir. Then what is remain? Huh? Tell me. Respondent number 2 heard personally. That LCR received. Yes. When do you want? And then I admit and appeal, it's my responsibility to finish as early as possible. Okay, this taking into account that the service is complete and the LCR has been received, lists the appeal for final disposal on 6th of May 2025. But the because it's given to both the parties. Remember? What is the affidavit in nuclear business? What is this matter? What are you challenging? Huh? No, what is this matter you are challenging? What order you are challenging?
I find out the petitioner will file a valid for the under section 13 of implementation for grant of report. Government petition matter, I filed my petition matter reflecting my in the same petition filed and the other side has filed application under section 24 of the same act for matter and maintenance content. And that was allowed matter.
10,000. Then you are challenging that.
Against the order matter, I have.
Why? You are challenging? What do you do?
My basic boundary is that my lord, along with his my lord, some under section 24 of the merger act, my lord, my lord, the other side, my lord, have not filed my lord, affidavit, my lord, respecting my lord, present income and my lord, assets and assets. Which is kind of mandate by my lord, rather than government employees.
Who? You are government employee.
But we have to check it.
Right?
I have that last number.
You are last member.
But I had to check that. They did not get any maintenance for my children. Both the children should be.
You are also a government servant. Who are you?
I'm my lord, great for my lord,
Wait for railway employee.
but this my lord, in my
And 10,000 rupees is given to whom?
by
For what? For the children. Huh? What is your salary?
I should have my lord,
46,000. And a affidavit of assets showing his income as 46,400, 695 per month. Along with the aforesaid amount of EMI which he pays for the house loan of fiancé. Then
Phase 57, my lord. And my lord, I think the my lord, 46,000. My lord, 58, my lord. I, my also, my lord.
with the people to the loan. So we will change it, pay this 10,000 per month towards the maintenance of the children. Why should we only spend on the maintenance of the children? How many children? My goodness, we increase it by 5,000. 7,500 minimum is required. We increase it by 5,000. That day, there was one lawyer who came up with this type of matter. I increased it by 5,000. We increased by 5,000. Wait, it is too less. You get 46,000. And why are you building a house for? We're getting married. Then, what are you building the house for? At 13 lakhs, putting in a loan of 13 lakhs 95. Why? Why? For whom? Your two daughters. Are these two daughters going to move in starvation?
I only get it.
Not only saying you need to withdraw. This type of litigation, if we encourage it, 1,000, you only change it, that it is 10,000 towards the retaining of chip. Not for litigation expenses, they in- but for 10,000, two children. Where is it? Where do you stay?
In an ambulance.
Where in Guwahati? Okay. Where does the student stay? Eat. The children is really. Eat. Going up down, too far from them. You are a central government and do what? It for central government employee get the law. When we change it only into this 10,000 for the maintenance of the chip. Think of it. Not for litigation. First 10,000. There's no stay also, na?
No, but
Huh? You, you know what to do. Well, you know what to do. They don't pay, you know what to do.
Yes.
If you don't put him behind bars,
Yes.
then you will lose the system. I- It's for big guns. I, I, see, I took that to pay an amount of 50,000 per month. Something very much maintenance, it is like the litigation expense. Council period had submitted for the important review is upmanned and as such and the government service and as such the question of making payment of maintenance rendered like the education expenses as directed by the legal bank like the district judge of the not proper. Going through the council is giving the capital plan on the giving of which that the that out of the wedlock there are two children who are studying in private schools and she is the only one who is bearing the entire expenditure for their well-being as well as for their school fees and for their education and other requirements. This was to be taken into account the taking into account the periods of record is of the opinion that the position of the amount of rupees 10,000 by the June already been 112,050 in the case number 8 of the when the commissioner by the 11th of the district from not does not appear to be erroneous, requiring interference by the scope. However, it is the opinion of the scope that the same amount of rupees 10,000 which the petitioner is directed to pay shall be used only for the purpose of the needs of the children of the petitioner and the respondent. The above the instant.
I do.
What do you want? Yes, what review you find? Okay. What is there to find?
We have time.
Huh?
I was, put it up for the worksheet. So, paragraph 10 mentioned by of my picture. Paragraph 10.
Paragraph 10 of what?
The appeal of description. Review it. Then we let- Every sharing number, which is your doing what, description was bring down, that they are student findings have no knowledge, so they shall be, and the moment executed by their death for a town of Toyga. Here's a copy of the shall be, and the only have been findings to them by the executioner number 21723. The review petitioner have gone to the office, which is our office, Mohatu, and apply for certificate of the application submitted by the respondent by this for mediation of the land left by their advent father of that number 2526, or number 579, and the certificate has been breached. We issue certificate copies of the application submitted to the respondent by this for mediation of the land. Particularly of the field land, the case which was registered as mediation case number 337 of 1340. Now, annexed E may be conditioned by.
Mr. Fakia, kindly appreciate one thing. This is your evidence.
What's it that?
This is your evidence.
Yeah, but this is subsequent, it is true.
Understood everything. I'm not saying that they don't know. I'm not saying, but you are to appreciate one thing. They knew about this thing. I have to only see from the plane. I cannot see anything of your defense.
Logic is just hear me, your logic is correct. But just hear me, I will see the annexed email. The annexed word, for a word, logic will check on annexed E at page 70.
This is your evidence.
That is documented evidence.
Understood, but I can't take it now.
No, logic said that they had no knowledge.
As per the plane,
Yes,
I didn't say that they had no knowledge. I say as per their playing, they had no knowledge.
has given a finding. But the
Yes.
time is only for a while. And what they have their knowledge and case. Submitting one, they are the application and case was registered. TG 7 of 1314 and watching mechanics, the order of license for page 76. For a while. Page 76. Applicant is present. Case is taken up for consideration. Process server has served the notices upon the portadors and has submitted the same report during the pendency of the case. There is no objection for anybody has come. The applicant number 1, Shri Hangaba Soikya, 5 of their town of Soikya, Shri Manik Soikya, Shri Bhupen Soikya, Shri Burpe Soikya, Shri Mandam Soikya, Vipul Soikya, son of their town of Soikya, everybody saw foreigner. Second part, applied for musician, again that number 2562, getting the portal number 579 on the, of the part of the land of their town of Soikya as inheritors. The report of the left on an examination of records of the case, it is seen that the portador left Arnold Soke has expired. The death certificate is produced, and the inheritors of left Arnold Soika, and that is Shankrapa Soika, so and so,
Then number 4.
Sir, India,
I don't know, the mother no, right, is there hearing. That's what they are. Mother to kind of sheep.
I'm not going to.
That was now the kind of sheep.
Is that annexure E a part of their document?
My lord, that was.
Is the annexure E a part of their document?
What's it, they're suppressing when they play.
Understood, but that cannot be a ground for that.
My lord, I will bring to notice, that will make my submission kindly. Kindly sheep, my lord. The page, my lord, on the page 77. Last line may be kindly sheep.
When is Mr. Kane sir will coming? Huh? We'll have it on 22. I think he will understand. Mr. Map on 25. 25, 25. When is 5? 5. 32. Three. First time. What is this? What enhancement? Why?
Could, come into a second, income, second.
How much you got?
I mean, the carpenter and the minimum for unlisted labor repeated.
How much you got? What is the amount given?
Not given is the 16 lakhs.
Huh?
16 lakhs.
What do you do?
Carpenter, carpenter is skilled labor.
So, enough.
7,000.
When did the accident happen?
It happened in nineteen.
So, enough.
No, look, this way. For enhancement,
We delay, we dismiss your condemnation application. No,
I have to submit that.
It is not the dismiss your condemnation application with 10,000 cost upon Mr. A.R. Agarwal. Well, this is not done. This type of application, carpenter getting 15 lakhs is too much, but fellow not getting the amount. You see, in total, the claimants are to receive total of 80 as compensation, 18 lakhs. Why you are saying 16 lakhs? And 9% interest. My goodness. But we dismissed this. That's the right. Type of application, no. Sorry. Judgment delivered on the return 155. Was the lower court council? Who is the counsel in the lower court?
Gurbanan.
Huh?
Gurbanan. Gurbanan.
And how much? And thereupon, no ground. In lakhs we have got English. So this means it- no ground. What explanation? You are a rustic villager. You are a rustic villager. And you want more than 18 lakhs. Huh? Then? No. First time I finished it. Today I have got a lot of time. Finish it for 40. Financial constraint. Financial constraint. And they have engaged A.R. Agarwal. Huh? A.R. Agarwal is being engaged financial constraint. Poor people. No, no, no. Is this? My goodness, we have got so many things. But found that the High Court lawyer has gone for Xmas, New Year long holiday. He's gone for Xmas holidays. Where did you go? Kashmir, Kashmir in Christmas.
Recently, I
No, you were not there in Xmas and New Year. I'm telling you.
but the best not the
Huh?
best
Vaishnav Devi in New Year's.
that is Navaratri is there.
Navaratri is now.
To visit the whole time.
Navaratri is twice. One is in the month of October and one is now. Then where is the question of Navaratri in Xmas and New Year?
Whenever you get holiday loan,
Don't tell me all this. After reopening the honorable court but could not go because of financial constraints and went on so and so after month you already and handed over a copy of evidence and other required documents to the High Court Council. The High Court Council opined the petitioner that there are good grounds for appeal. Now let us see what they are the good grounds for appeal. Let us see. What are the good grounds? Let us see what are the good grounds. Is that properly done? It is nothing. What was the good ground? Did you give any evidence for that he was late? Let us see how much. it was.
you know, my just taken the, that is unskilled taken the. So you
He
are
believed
carpenter service,
because it is evidence that the victim was a businessman and earning was 15,000. Another counsel for the insurance has stated we have basic the income of the deceased. I have gone through the figures, found there is no evidence or record about the income of the deceased. In the cross-examination has admitted that he has not submitted any document with respect to occupation and income of the deceased. Learned counsel for the inquiry rightly argued that the one has paid to prove the occupation and income of the deceased. Now, so and so, for the sake of removal of doubts, remove what I am saying, has been given as minimum wage of asking workmen and so is 7,900. So, but fantastic judgment. It is dismissed.
they have to look at my annual.
No, no,
This first time,
first time, nothing.
we are going to have very
No,
big annual.
only this. Okay, we dismiss for today. Another day. I am not going to issue notice. I am dismissing it.
Then after three,
We have it on 2nd of May. For dismissal.
I have been told that notice.
No, 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 no.
Next, without notice,
No, nothing big.
next, notice.
Show me a document by which he was a carpenter. Then only I will issue. Show me a document.
Very good. I am.
No, nothing will.
I'm with
Only on second, you get ready with a 50,000 posts. Don't say, okay. This is the matter on second of May 2025. For further consideration, it is required to be issued with the confirmation application. 24. Forty-five.
one of the 70
Huh?
170
First time,
what about
45.
45?
Who is paying for response number one? What is it? 45. I don't put in LCA can get it. LCA. What is it? LCA. Why do delay?
For medical requirement.
Huh?
For medical requirement.
What are the medical needs?
And I thought, where the
Real low back pain.
this
Who is this?
is one of the
How much you have got? How much you have got? Which is the RSA? Huh? So brutal is it? 45. So brutal is the MIT. Please do. 45 is no. 45 is it? What is it? Respondent. Your name also not reflected. Obviously, respondent. This is the first time noticing. No, he has put it on. Next. 46. First time.
And
First time.
Right.